Well, it's a great pleasure to be back at my old university. I thought after 42 years nobody had ever asked me to come and speak here, but here I am. The first expert witness used in the British courts was John Smeaton. He was the builder of the Edison Lighthouse in Folkes versus Chad case in 1782. It was a case about a harbour in Norfolk. Lord Mansfield allowed Smeaton's testimony despite the fact that he'd not even been involved on a day-to-day basis with the case. But that in itself established a significant precedent in common law, allowing individuals with specialised knowledge to provide opinion evidence within their field to assist the court. The ruling was important in that from then on opposing sides could bring their own experts and assert their opposing claims. So where are we today? We have a system whereby experts are paid by one side or the other, but in criminal cases where legal aid is involved, the pay available to experts on the prosecution side is likely to be much greater than that available to the defence. And this causes an immediate disparity and unfairness. How does an expert become an expert? Mainly by stating that they are an expert and persuading anyone who will accept that as a fact to hire them. In the field of medicine, there is no strict definition of an expert. There are, however, strict guidelines, and these are given by various of the expert medical bodies, and these are published by the General Medical Council, the Royal College of Surgeons, the Academy of the Medical Royal College, as well as the Royal College of Paediatrics and Child Health. But these guidelines are honoured more in the breach than in the observance, as witnessed in the Crown versus Letby. The past chair of the Academy of Medical Royal Colleges, Professor Dame Carrie McEwen, who's now the chair of the GMC, has stated, expert witnesses must be fully up to date and act with complete integrity. Yet the GMC, and some of the doctors in here will know from their own experience, the GMC refuses to engage with doctors who have reported breaches for relating to the Crown versus Letby. The Faculty of Forensic Medicine, which acts under the governance of the Royal College of Physicians, states that to act as a medical witness, a doctor must stay on the medical register and be licensed, even if retired. And in that case, only give opinions on issues that had occurred during the practice of that particular witness. The faculty states that there is no way around this. The faculty is wrong. The advice, the guidance, the rules, the ethics, all have a coach and horses run through them regularly. And those who are complicit are the police, some lawyers, the CPS, some judges, despite the rules being set out very carefully in the Criminal Procedure Rules 2020 and currently in the Consolidated Procedure Rules 2025, the practice as advised is not adhered to. In the case of Lucy Letby, one of the experts giving evidence concerning neonates during the events of 2015 to 2016 had retired from clinical practice in 2007 and was not formally trained as a neonatologist. He worked on the instructions of the Cheshire Police without being licensed by the General Medical Council whilst he was producing all of the evidence, so-called, prior to the trial. In the Crown versus Letby, another expert had had substantial restrictions on his medical practice in the time adjacent to giving medical evidence, but it's unclear if any of this was given to the defence, and post-trial his name disappeared completely from the General Medical Register. So neither of the two main CPS-appointed experts have any published academic papers regarding air embolism or insulin, which were two of the main features in the trial. And the first has no peer-reviewed papers at all, the second only having 8 papers from 25 years ago. None of these had any relevance to the trial. Both had been subject to complaints to the GMC, and the main expert, Dr. Evans, had been criticised by judges on several occasions, both in Northern Ireland and much more recently during the trial when Lord Justice Jackson reported to Judge Goss that he had significant concerns. However, this was completely ignored, and Dr. Evans was allowed to continue giving evidence, much to the surprise of many people. So how did we get here? There's a catalogue of medical experts who've participated in conviction of innocent people over many years. Probably the most notorious was Sir Bernard Spilsbury in the 1930s, whose work almost certainly led to the deaths by hanging of totally innocent people. More recently, there have been notorious cases of miscarriage of justice, examples being in the case of Sally Clark and Angela Cannings that most of you will have heard of. They were both eventually exonerated of murdering their babies. But two doctors in that case, Sir Roy Meadow and Dr. Alan Williams, a consultant histopathologist, were subsequently accused of serious professional misconduct as a result of their evidence. Meadows having given totally inaccurate statistical evidence outside his field, and Williams due to failure to disclose evidence. Professor David Southall, a paediatrician, and Dr. Arnhem Bentavin, a child psychiatrist, were also held to account over the false conviction of Sean Jenkins for murder, who was eventually exonerated after spending 6 years in jail. More closely related to the Lucy Letby case, Dr. Martin Moore-Platt, a neonatologist, was involved in the wrongful conviction of Donna Anthony in 1998. She was exonerated after 6 years. Dr. Ward-Platt was struck off the GMC register for a while, but interestingly, he had been appointed to be Dr. Dewey Evans' wingman in this particular case of Crown versus Letby, and he in fact died fairly suddenly and was replaced by Dr. Sandy Bowen. An interesting theme pervades the connections between some of the doctors disciplined by the GMC years ago for having been involved in some of the above serious miscarriages of justice. And some of the expert witnesses and other medical witnesses in the Lucy Letby trial seem to have had some connection, at least with the ideas that had been purveyed by Drs. Southall, Meadows, etc. Dr. Evans appears in the case of Lucy Letby to have had some suspicions regarding some form or other of Munchausen's by proxy, as it might have related to Lucy Letby. And it seems there's also a considerable interest in that area, which is now called FII, fabricated or induced illness, by Dr. Bowen. So there's little effective control regarding the quality of experts. Experts who regularly give evidence in court are largely self-anointed because there is no control over who can call themselves an expert. In practice, an expert is an expert if they can persuade a lawyer or the court to instruct them, regardless of whether either body have got the knowledge to distinguish between a genuine expert and a charlatan. Really, such an assessment can only be made properly by a body of peers. The Lucy Letby trial showed that some experts were manifestly inappropriate and failed to meet recommendations of the Royal Colleges or failed to be properly regulated by the GMC. Regardless, the police and the Crown Prosecution Service appointed them anyway. The court allowed evidence from these experts, one of whom was not even licensed when they were working for the police, and others who had been restricted by the GMC. Had a system been in place whereby the police or the court had been advised by a panel of true experts, it is vanishingly unlikely that any charges would have been brought in this case, least against Lucy Letby. Instead, pseudoscientific expert evidence, which has since been roundly rejected by senior members of the medical profession, have been allowed to override common medical knowledge and medical sense. In 2011, the Law Commission produced a report of expert evidence in criminal proceedings in England and Wales. This had been prompted by a House of Commons Science and Technology Committee report in 2005 called Forensic Science on Trial, which in itself had been prompted by the scandals of Angela Cannings and Sally Clark. There were 22 recommendations, and although the government, 2.5 years later, subsequently conceded concern about some of the problems that had been raised by that report, they decided that the cost of savings by ignoring those recommendations overrode the problems of miscarriage, valuing money and convenience over justice for victims of the court process. It seems government and the judicial system don't care very much about this type of injustice. They don't care particularly about the many people who are in jail, as described a moment ago. And they don't care about faulty medical evidence being used.